All right, Wednesday, a federal courtroom in Washington, and a sitting president's medical claims just got shredded. On the record, under oath. Here's what happened fast. According to court documents filed this week, Attorney General Pam Bondi submitted physical evidence directly contradicting sworn testimony about Donald Trump's health. The judge didn't let it slide, didn't table it for later, called it out right there in open court. I've been going through the transcripts and the accompanying filings since they dropped Tuesday afternoon, 47 pages, read them twice. What I found isn't just embarrassing, it's legally significant in ways most coverage is missing completely. Let me show you what's actually in there. Quick context. Trump, 47th president, currently facing a civil contempt proceeding tied to disputed health disclosures submitted to a federal oversight panel earlier this year. The issue? Sworn statements about his physical condition appear to conflict with medical records his own Justice Department inadvertently placed into evidence. Timeline, fast version. Several weeks back, Trump's legal team filed a formal health declaration. Standard stuff on the surface. But they used it to justify delays in scheduled testimony appearances, missed 2 of them. A few weeks after that, the oversight panel pushed back, formally, said the delays weren't medically supported, requested DOJ produce the underlying records. Then last week, Bondi's office actually complied. Whether that was strategic or an oversight, still being debated. That's when everything unraveled, because the records DOJ turned over didn't match what Trump's personal attorneys had been telling the court. Not slightly different, materially different. And Judge Patricia Hensley, 22 years on the federal bench, former assistant U.S. attorney out of the Eastern District of Virginia, she noticed immediately. That's the setup. Now the documents. Okay, the evidence. First document, the health declaration itself, filed by Trump's legal team 11 days ago. I pulled page 9. It states, quoting here, the patient exhibits significant cardiovascular limitation, precluding extended periods of physical or cognitive exertion without medical risk. That's not casual language. That's clinical, specific, designed to carry legal weight. What it means, Trump's attorneys were arguing he physically couldn't sit for prolonged testimony sessions. Medical necessity, not preference. But here's what got me. The DOJ document production, page 31, different section entirely, the physician's internal progress notes from the same examination period. Those notes describe, and again, I'm pulling directly from the filing, patient demonstrates age-appropriate cardiovascular function. No acute limitations identified. Activity restrictions not recommended at this time. Put those 2 things together. Yeah, that's a problem. I went through this section 4 times. The gap isn't interpretation. It's not framing. The clinical conclusions are opposite. Trump's legal declaration, significant cardiovascular limitation. DOJ produced physician notes, no limitations identified. Both documents, allegedly from the same examination window, all in the same court record now. Now, what nobody's covering. The physician who signed the limitation declaration, according to a cross-reference in the filing, page 44, footnote 7, he's not listed in the White House Medical Unit's official personnel roster for the period in question. 19 months of records. His name doesn't appear. Read that again. The doctor who provided the medical justification for missing federal testimony may not have been the treating physician on record. Judge Hensley flagged this at 11:14 a.m. Tuesday. Publicly, in open session. Her exact words per the official transcript, counsel, I'm looking at 2 documents that cannot both be accurate. Explain that to me. Trump's lead attorney, Raymond Callaway, asked for a recess. Got 7 minutes. Came back. Said he needed time to investigate the discrepancy. Hensley gave him until Friday. Fallout. The contempt question, which was already on the table, just got significantly more complicated. What started as a scheduling dispute now has potential fraud implications attached to it. 3 separate legal watchdog organizations filed amicus requests within 6 hours of Tuesday's session ending. And the White House Medical Unit, which had been quiet throughout this entire proceeding, issued a 1-sentence statement Tuesday evening. "We do not comment on matters before the federal courts." That's it, 1 sentence. Within 24 hours of that statement, 2 news organizations reported that internal communications between the medical unit and Trump's private legal team are now being sought through subpoena. Not confirmed, but both outlets cited separate sources. That's just the first layer of documents. Subscribe. I'm not done with this filing. And when the Friday response comes in, I'll break it down the same way. More coming on this. Okay, but look, gotta be fair here. The other side has a point. A few points, actually. Trump's defenders, and there are serious legal voices among them, say this entire proceeding is politically constructed, that the oversight panel pushing for testimony was never acting in good faith, that the medical documentation dispute is being amplified way beyond what the underlying law actually requires. And honestly, some of that holds up when you look at it straight. Their argument, first, executive medical privacy. Presidents operate under a unique set of disclosure constraints. There's legitimate legal debate about how much health information a sitting or former president must submit to any oversight body, especially one with disputed jurisdictional authority. This isn't a settled question. Second, the DOJ production itself. Trump's legal team is now arguing that Bondi's office released documents without proper privilege review, that the very records causing this firestorm shouldn't have been in the court record at all. And if that argument succeeds, the evidentiary foundation collapses. Former White House counsel and constitutional law attorney Bradford Simmons, who has represented clients across both parties, put it plainly. Procedural production errors don't become substantive admissions. The origin of these documents matters legally. Don't agree with all of it, but that's not nothing. What they've got working for them? The oversight panel's jurisdiction has been challenged in 2 prior filings, neither fully resolved. Executive medical records exist in a complicated privacy framework that courts haven't uniformly addressed. Bondi's office hasn't confirmed whether the production was intentional or an error. Even the American Bar Association's formal ethics commentary, cited in a brief filed by Trump's team Monday, acknowledges medical documentation in executive proceedings carries distinct confidentiality considerations not present in standard civil litigation. When both sides can cite legitimate legal authority, that's when you know this is genuinely complicated. Look, I'm not here to hand you a verdict. The skeptic interpretation, there's evidence for it. The fraud interpretation, there's evidence for that too. Both can exist simultaneously. That's what makes this legally dangerous for everyone involved. What I can tell you is what the documents actually show. And they show a judge who's no longer willing to let the procedural fog do the work. Hensley has now ordered both sides to submit a joint evidentiary timeline by Friday at noon. Every document, every signature, every date. That's not standard practice. That's a judge who thinks someone has been playing games with her courtroom. And that's where we go next. This didn't come out of nowhere. Backstory quick. About 8 months ago, the Federal Oversight Panel, formerly the Executive Conduct Review Board, began requesting voluntary testimony from Trump on a separate financial disclosure matter, routine ask on paper. About 5 months ago, Trump's legal team began citing health concerns as grounds for postponement. First request granted, no controversy. About 3 months ago, second postponement request. Panel pushed back quietly, still granted, but the internal correspondence later made public through an FOIA release showed growing skepticism among panel members. Someone on the panel even wrote on the record in internal minutes, "We are no longer satisfied that the stated medical grounds reflect the actual situation." That was 3 months ago. Nobody picked it up then. What happened between then and now? The panel escalated, quietly at first, then formally. Pattern: delay requested on medical grounds. Delay granted without documentation review. Delay requested again on same grounds. Documentation finally demanded. Documentation produced by the wrong office or the right office at the wrong time. Every single cycle, the medical rationale held just long enough. Until Tuesday, when two sets of records sat side by side in front of a federal judge who'd seen that particular move before. Hensley didn't wait for a motion. She asked the question herself. See where this trail leads. Hit like if the breakdown's making sense. Helps more than you'd think, and it tells me this kind of deep document work is worth doing. Tuesday, 11:14 a.m., open session. Here's what happened. No buildup needed. Judge Hensley held up both documents simultaneously, physically, in open court, addressed Trump's lead counsel directly. Counsel, I'm looking at two documents that cannot both be accurate. Explain that to me. Calloway asked for recess. Room went quiet. 7 minutes later, he returned with no explanation. Said his team needed time to investigate the internal discrepancy. Asked for a 48-hour continuance. Hensley denied it. What followed? Hensley ordered a joint evidentiary timeline due Friday at noon. She formally placed the contempt question in active consideration, not tabled, not deferred. She requested that the White House medical unit provide a sworn representative available for questioning no later than July 1st. 11 minutes. That fast. Now. What everyone missed while focusing on the courtroom drama, while coverage fixated on the visual judge holding up two documents, something else happened simultaneously in the same session. Bondi's office filed a supplemental notice. Quiet. 2 pages. At the bottom of the docket. That notice stated DOJ has additional medical records beyond what was produced Tuesday, and that those records are, quote, currently under privilege review. Then came the next development. Hensley saw the notice, asked DOJ counsel about it directly. DOJ counsel said, and this is in the transcript, page 67, they couldn't characterize the additional records without completing the review. Hensley's response, she set a deadline. July 3rd. All records, privileged or not, submitted for in-camera review. She'll look at them privately and decide what stays and what comes in. That's not a standard order. That's a judge who no longer trusts the filtering process. You can see it in how she worded the order. Precise, deliberate. She's building a record. This is where it gets interesting. Don't go anywhere. What I break down next, the expert read on what in-camera review actually means for Trump's legal exposure, that changes the picture significantly. Drop your prediction below. Then keep watching to see how close you got. What are legal professionals saying? Former federal prosecutor, 11 years in the DOJ Public Corruption Unit, tried 4 contempt cases against public officials. When a judge orders in-camera review, rather than waiting for parties to resolve privilege disputes themselves, she's signaling she doesn't believe the privilege claims are being made in good faith. Plain English? Hensley thinks someone is using privilege as a stall tactic, and she's cutting around it. Another voice, former assistant U.S. attorney, Southern District of New York, now a criminal defense attorney with 2 decades of post-DOJ practice. The physician identification gap is the real problem here. Medical declarations submitted to federal courts require a verifiable signatory. If that physician's credentials don't hold up, the declaration itself could be struck. Everything built on it collapses. Key there, it's not just embarrassing. If the declaration gets struck, every postponement granted on that basis gets reviewed retroactively, which means the panel's contempt argument gets significantly stronger. Here's what's interesting. Even a constitutional law professor at Georgetown, who has publicly been skeptical of the oversight panel's jurisdictional authority and has written op-eds favorable to Trump's legal position, said this week, whatever one thinks of the panel's standing, 2 irreconcilable medical documents in the same proceeding is an evidentiary problem that can't be explained away procedurally. When someone on the opposite side of this debate says that, Pay attention. Consensus across the legal community right now, the in-camera order is a significant escalation. Physician credential verification is now the central factual question. Contempt is no longer a remote possibility. It's the likely next step absent a credible explanation by Friday. That's where professionals land, across both sides of the ideological divide. If this breakdown is useful, hit like. I put serious time into pulling the actual filings rather than just reacting to headlines. The like helps, genuinely does. Why should you care? Real talk, how this actually connects to people outside that courtroom. This sets a precedent that reaches well beyond Trump specifically. The core legal question being established right now: can medical documentation be used to indefinitely delay compelled federal testimony? If Hensley finds contempt and the Friday response is inadequate, the answer becomes formally no. Not without rigorous, independently verifiable medical evidence. Next time you or anyone faces a legal obligation tied to health status, whether it's a workplace dispute, an insurance claim, a disability filing, a court appearance, the standards being written in this case start mattering. Courts cite each other. That's how law works. Right now, roughly 340,000 federal civil cases are active in U.S. district courts. Medical documentation is submitted in a significant portion of them: disability claims, personal injury, workers' compensation-linked litigation. If this case establishes tighter verification requirements for medical declarations, that affects processing time, appeal rates, and evidentiary standards across all of it. Not immediately, but within 18 months, legal analysts are already saying you'd see the ripple. If you've ever submitted a doctor's note to a court, an employer, or a federal agency and had someone take it at face value, that system is being stress tested right now. The assumption that medical documentation is inherently credible, Hensley just put a flag on it. Uncomfortable part: if the physician verification gap holds, if that doctor's credentials don't clear, then sworn medical evidence was used to obstruct federal proceedings. That's not a procedural technicality. That's the definition of fraud on the court. And fraud on the court carries consequences that personal legal exposure doesn't automatically cap. If you followed this case, assuming it stays civil, stays in contempt territory, that assumption may need updating by next week. What informed people following this situation are doing: watching the Friday noon filing deadline as the next definitive signal, tracking whether DOJ files a formal privilege log before July 3rd or goes silent, asking if Bondi's office produced these records, why? And does that reflect internal disagreement within DOJ about how hard to protect Trump? The third question is the one worth sitting with. I'm not saying Bondi moved against Trump intentionally. I'm saying the records got produced, and whoever made that call knew what was in them. Knowledge helps here. Understanding the structure of what's happening is how you read the next development accurately when it lands. How did Trump respond? Made it worse, honestly. Within 3 hours of Tuesday's session ending, he posted on Truth Social, called the proceeding a weaponized medical inquisition run by Bondi's rogue office, said the documents were stolen and misrepresented by judicial activists. Reaction was immediate. The post was screenshotted and submitted to the court record by the oversight panel's attorneys Wednesday morning. Legal commentators across the spectrum flagged it as potentially relevant to the contempt analysis, public statements attacking the proceedings while contempt is being weighed. Trump's own camp, separately from official legal counsel, walked it back slightly within an hour. A spokesperson said the post reflected understandable frustration and wasn't meant as a formal legal position. The oversight panel came back with one line through their communications director: the documents speak for themselves. Then, Tuesday night, a second development. Callaway, Trump's lead attorney, filed a motion arguing Hensley should recuse herself, cited a 2021 speech she gave about executive accountability as evidence of bias. Hensley denied the recusal motion Wednesday morning. 2 paragraphs, no lengthy explanation, just denied. That move, filing recusal during active contempt consideration, is not going to help Trump's Friday submission look like good faith cooperation. Not cooling down, heating up rapidly. What's still unclear: 1. The identity and credentials of the physician who signed the health declaration. Trump's team has not confirmed who it is. The court hasn't forced disclosure yet, but Friday's joint evidentiary timeline will almost certainly require it. 2. What's in the additional medical records DOJ flagged in the supplemental notice? If they support the limitation declaration, this all looks very different. If they support the progress notes, the situation accelerates dramatically. Coming. Judge Hensley has the joint evidentiary timeline due Friday, June 27th at noon. Trump's legal team is reportedly working through the night, according to 2 people familiar with the filing preparation, on a response that addresses the physician credentialing question directly. The White House Medical Unit has been asked to have a sworn representative available by July 1st. And Hensley's in-camera document review deadline sits at July 3rd. Date to watch, Friday, June 27th, noon Eastern. That's the first hard deadline. Whatever Callaway files or fails to file by then tells you where this goes next. Should know significantly more by Friday afternoon. Subscribe. I'll cover the Friday filing the same way I covered this one. Documents first, headlines second. Stories moving fast. Notifications on if you want to catch the breakdown when it drops. Where we are right now. Federal contempt proceeding. Active, with Hensley presiding. Not paused, not deferred. Trump's legal team under Friday noon deadline to explain 2 irreconcilable medical documents. DOJ supplemental records under privilege review due for in-camera submission by July 3rd. Recusal motion filed and denied Wednesday morning. White House Medical Unit subpoena for sworn representative, July 1st deadline. Scheduled Friday, June 27th, noon. Joint evidentiary timeline due from both parties. Tuesday, July 1st. White House Medical Unit representative availability deadline. Thursday, July 3rd. All additional medical records due for Hensley's in-camera review. Week of July 7th, contempt ruling expected, pending Friday's submission. Not confirmed yet whether Callaway intends to request emergency appellate review of the in-camera order before July 3rd. That would be the delay play. And it would tell you everything about whether they have a legitimate answer to the physician credential question. Clock is running. That's where we are. Trump's medical documentation, formally contested in open federal court by records his own Justice Department produced. Surface read, a legal embarrassment, an administration caught with contradictory paperwork. But the in-camera order is what I keep coming back to. Hensley didn't have to do that. She could have let Friday's filing play out and ruled on what was submitted. She went further. She wants to see everything herself. That's a judge who thinks the document problem is bigger than what's visible. And the recusal motion filed during active contempt consideration? That's either a Hail Mary or the beginning of an appellate strategy. Either way, it signals Trump's team doesn't have a clean answer to the core question. I'll be watching Friday's noon filing, specifically whether Callaway names the physician or doesn't. Story's not over, still developing in real time. Subscribe for the full picture, not just the headlines. When the Friday documents drop, I'll break them down the same way I broke this one down. Page numbers, direct quotes, plain English. Talk soon.